Hello everyone, welcome. On this session, we are dealing with the course The Understanding Competition Law Theory and Practice. Now we are dealing with the fourth module, and today we'll take up with the second lecture of this particular module, and we'll discuss the types of horizontal agreement. And the objectives of the today's session is to discuss the meaning of price fixing agreement under horizontal agreement. So before going into detail, let's have some snap of previous session. In last lecture, if you remember, we have discussed the meaning of horizontal agreement and vertical agreement. Actually, what we have discussed is there are two types of anti-competitive agreement within the meaning of section 3, and that is horizontal agreement, which comes with the provision 3(2)(3), and vertical agreement, which comes within the meaning of under the provision 4 to section 3, that means 3 section 3 subsection 4. Under both type of agreement, there is a basic difference, and the difference is horizontal agreement is such type of agreement which comes within the meaning where two are the entity or competitor where they are supposed to compete with each other actually comes in such understanding, practice, collusive behavior, conduct or agreement at the same level for certain reason which have adverse impact of competition on market like price fixation, allocation of price or other form of bid rigging, etc. And there are second type of agreement, which means the vertical agreement. Vertical agreement are such agreement where it comes with the two competitor where they are supposed to compete or they are supposed to not to comes within the collision or any anti-competitive practices, but they comes into agreement to restrict the competition or to reduce the competition or to fix the price at the same level of supply chain at the different level. That means in a same supply chain at different level, like manufacturer with retailer or retailer with supplier or supplier with distributor. So the horizontal agreement or vertical agreement, horizontal agreement involve the collaboration between the competitor operating at same level of production or distribution, and vertical agreement are agreement where involve with the firms at different level of production and they for the purpose of price fixation, exclusive or distribution, exclusive supply, tying or refusal of deal. And it includes directly or indirectly determination of purchase or sale price, limit or control the production supply market, share the market, directly involved in bid rigging. And these are the provisions what we have discussed in last session. So today we are going to deal with the directly or indirectly determination of price or sale, which is popularly you can say in a single phrase price fixation agreement. So what is price fixation agreement? Price fixation agreement is an agreement which is prohibited under section 3 subclause 3A, which prohibits the price fixing agreement, the agreement through which the companies mutually set the price that they want to change in the market, and that are called price fixing agreement. Imagine a market where four firms manufacturing white cement and they are agreed to sell their product at a fixed price. Although sometimes a slight increase in the price of each product hardly matters to a consumer, such price fixing will ultimately generate huge profit for the colluders. Other types of price fixing agreement includes agreement that jointly predetermine the size of profit margin, the extent of discounted and the level of price increases, like agreement on price increase, agreement to adhere the published price, agreement on a standard price formula, agreement not to sell it is on agreed price term, agreement regarding the providing elimination or establishing the method of providing discount, and agreement on credit term that will be offered to customer. In Arizona versus Maricopa County Medical Society, decided in 1982 by US Supreme Court, where the court observed that the aim and object of price fixing agreement is the elimination of one form of competition. Such agreements are made by way of informal understanding as the price of preventing competition and keeping the price up. The power to fix prices, whether reasonably exercised or not, involve the power to control the market and fix arbitrary and unreasonable price. Again, one more case in India, if you see, the FICCI Multiplex Association of India versus United Producers or Distribution of Film and the decision of the CCI. A United Producers firm not to release film, Hindi film, to multiplexes in order to pressurizing them collecting decision was taken by United Producers and Distributor Forum into accepting new terms of revenue sharing ratio. And UDPF issued a notice instructing that producer and distributor, including those who are member of UDPF, not to release any Hindi film for the purpose of exhibition at the multiplex. And a complaint was registered with CCI and CCI directed for the investigation. See what happened in this matter actually. In this matter, United Producer Film Production, which was association of producer, they are demanding for certain specific ratio or in the form of commission from the price what they are earning. That means collective decision. It was the collective decision of the forum, that is UDPF, and they are demanding. And until their demand has been completed, they are not going to release any Hindi film or at the cinema hall or the multiplex. So a complaint was registered with CCI, and CCI what CCI did? CCI report of Director General UDPF was controlling almost 100% of market for production and distribution in Hindi motion picture with exhibited in multiplex in India, and UPDF that is forum were acting in concern of fixed sale price by fixing revenue share ratio in violation of section 3(3) of A of this act. Beside this, they were also limiting controlling supply by refusing to release Hindi picture in multiplexes in violation of section 3(3)(A) of the Act. And the Competition Commission held that agreement entered into the opposite party is covered within the contour of clause A and B of section 3 sub 3 of Act of the Act. Means, if suppose there are two entity enterprises or association of enterprises where they are supposed to compete with each other or where they are rival with each other, and they comes into understanding or agreement or any practice, whether that is informal in writing or not, and the impact is like they are actually decided to fix the price, or if the conduct or the understanding what they comes within is like the impact would be like fixation of price, and that will harm to the consumer, because consumer have nothing but they have to take that product or service at that price which is already set by the competitors. That means without any competition but by the understanding where they comes into agreement. So this type of agreement, if CCI found after the investigation of DG, that will comes within the meaning of anti-competitive agreement, because it is for price fixation, and price fixation is a such agreement which comes within the meaning of anti-competitive under section 3(3)(A). The second thing is output limit agreement. What is output limit agreement is basically, if you see section 3 subclause 3, that is horizontal agreement, the B provision under the subsection 3(B) is which is for the purpose to prohibit agreement regarding limitation or restriction on quality control. There can be a scenario where competitors agree to restrict and control the production, thereby controlling the supply in market. Output restriction can take place through various forms, including agreements on production volumes and agreement on sales volume. Agreement with limit or control production, supply market, technical development, investment or provision or service are considered to be the anti-competitive. And for the two reasons, if you look, there are two particular reasons why they are supposing this is like the anti-competitive, just because by controlling production, this supply is kept low as compared to demand, and therefore it creates actually artificial scarcity in market. That means if you down the supply or you kept low the supply in the market and demand is high, the result will create artificial scarcity and it will lead to increase the price. And second one, the agreement in fact where the effect is like restrict competition between the parties selves so that the efficient ones among them could not go ahead with further production and elbow out of the less efficient. So it will be the result like the increase in price and harmful for the consumer and will adversely impact the market in the competition in India. So the objective of controlling and limiting supply is to create scarcity in the market and subsequently raise prices in the market. Such output restriction agreement lead to dead weight loss in the society. So for this reason, output limiting agreement or any agreement which limits the supply or which actually reduce the output or which restrict the output in market supply or reduce the competition is deemed like anti-competitive. Let's see an example. Suppose there are two manufacturers of LED bulb, that is Philips and Syska. This is only illustration, so don't take the name of the brand as a brand name for any other purpose. This is just an example to understand the meaning. Suppose there are two manufacturers of LED bulb, that is P and S, and P and S enters into an agreement to limit their production of LED bulb to 1 million unit per month. This agreement restricts to output LED bulb, reducing the supply in the market and potentially leading to higher price. Why is this agreement is prohibited? Is this agreement is prohibited or not? Definitely this type of agreement is prohibited, and the reason is actually it restricts the output. Suppose if they are in collision or the agreement to limit the production, this agreement will lead to the limits the production of LED bulb, which will reduce the supply in the market and definitely have potential to impact for increasing price. Otherwise, potentially distort the prices by reducing the supply. The agreement may lead to higher price and will harm to the consumer and market. And definitely it will reduce competition. The agreement between the Philips and Syska reduce the competition in the market as other manufacturer may not be able to produce the same supply LED bulb at competitive price. So with this reason, the agreement or any agreement which is like or which is presumed, the impact is presumed is like the result will adversely impact on market in competition in India, particularly by limiting the supply and restricting the competition. There means the impact is like restriction on competition and the result is like increasing in price, but the act involved is limiting or controlling the supply. So that's why any agreement which takes place between the two competitors at the same level of different supply chain for the purpose of to limit the supply or output is deemed as anti-competitive. The third one is market sharing and allocation. How market sharing and allocation is important? Because this is another common horizontal agreement among competitors in the market sharing. These are also called market allocation and market division. It is prohibited under section 3 subclause 3c, and under such agreement the competitor agree to divide among themselves specific territories where they decided where they have already decided, and they distributed or divide the territories for the purpose of sale, customer or product. Such market allocation action are restrictive in nature because they leave no room for competition in market. For example, an agreement among competitor to allot certain customer to particular seller and to allocate or divide sale territories would be anti-competitive. Geographic market sharing is particularly restrictive from customer's point of view since it diminishes the choice. So, market division or allocation scheme are agreement in which competitors divide market among themselves, and in such a scheme competing firm and allocate specific customers or types of customers, product or territories among themselves. For example, one competitor will be allowed to sell to or bid or contract led by certain customer or type of customer. That means in return he or she will sell to a bid to contract led by customer allocated to the other competitor. Let's see one example of this market allocation. Suppose two soft drink manufacturer, one is Coca and second one is PepsiCo. The Cola and PepsiCo enter into an agreement to divide the Indian market among themselves, and as per agreement Coca and Cola, that is Coca-Cola company, what you are saying, will focus on the northern and western region, while PepsiCo will focus on the southern and eastern region. This agreement is market sharing horizontal agreement as it involves the dividing the market among competitors. That means, suppose there are two competitors or two enterprises where they are supposed to compete with each other, but they are not interesting to compete with each other, rather they comes into an understanding or the practicing what they have adopted, that they have decided to distribute the market at the map, like the geographical region, certain part of market with one and certain part of market with other, and this decided that they will focus their marketing, their branding, their selling supply for that particular market or as per the understanding of division. What happened in this type of agreement? Actually, this type of agreement is prohibited. Why this type of agreement is prohibited? Because this type of agreement comes within the meaning of market allocation, and market allocation comes within the meaning of which is prohibited under section 3 subclause 3b. Why? Because they reduce competition, they harm consumers, and they distort market dynamics. How they reduce competition? Because by dividing the market among themselves, Coca-Cola and PepsiCo reduced competition, which can lead to higher prices and reduced innovation, and they harms consumers. How? The agreement can harm consumers by reducing their choices and increasing price. And how they distort market dynamic? The agreement can distort market dynamics, leading to inefficient allocation of resources and reduced economic growth. So, by the reason, because any agreement which takes between the two competitors at the same level at different supply chain for the purpose of allocation of market or allocation of geographical region will result like hampering to the consumer interest and will discard the competition and will distort the market economic and market dynamics, and that will ultimately harmful to the consumer by reducing the price and reducing the consumer. That's why in that scenario this is assumed to be competitive and anti-competitive and will fall within the meaning of section 3 subclause 3b. So in summary, if you see, market sharing horizontal agreement are prohibited because they can lead to reduced competition, higher prices and harms consumer. Actually, the case what we are discussing here, the Citizen Watch Company of India Limited versus Hindustan Lever Limited 2005. In this case, the Competition Commission of India investigated a complaint against Hindustan Lever Limited and Reckitt Benckiser, that is India's company, for allegedly entering into a market sharing agreement in toilet cleaner market. The CCI found the companies had divided the market among themselves with HAL, and CCI, after the investigation reported by the DG, found that there was basically the understanding, or definitely there was no any agreement which is informal, but there was an understanding between both the companies or enterprises where they have divided their market without that means they were the enterprises who were supposed to competition, because competition lies for the purpose of to promote the competition, but the CCI found that they actually restrict the competition because they have allocated market or divided market as per the understanding. And the result is like, because of this division of market, they are focusing on the market what they have already divided or allocated. That means it will reduce, it is likely to reduce the negative impact on market, on competition within the India. And we have already know that under section 3 subclause 3b, any type of the agreement which is for sharing the market or allocation of market is restricted and prohibited, and if the conduct is taken by this type of conduct or practice comes within the meaning of anti-competitive agreement. So with this, if you try to find out the meaning of price fixation or the allocation of price or any competition within the meaning of horizontal competition, these are the competition which are for the purpose, this means these are the agreement which is for the purpose to reduce the competition in market. These competition which take place are supposed to take place and should be promoted from the competition, and the basic object of this Competition Act is to promote competition. So in this, if any activities took place where CCI found that competition is missing, rather agreement is lead to distort the competition, that will be harmful, and CCI will took it serious, because CCI is just to regulate these type of activities, and CCI will frame its regulatory measure under the provision under this act, and particularly this type of the agreement comes within the meaning of section 3, which is known as anti-competitive agreement and restricted. So what we have discussed today is basically the types of horizontal agreement, but we have discussed only the 3 horizontal agreement. There is one more important aspect of horizontal agreement, that is called bid rigging. Bid rigging or collusive bidding is a very important aspect of this horizontal agreement, and we will take this horizontal agreement in the form of bid rigging in next lecture. So for today, you are advised to go with the literature or the other books and the reference material regarding the horizontal agreement, and took some examples of what we have discussed in today's session. Take some examples and try to find out how you are able to identify the nature of any agreement whether it is horizontal agreement or not. Whether it is a horizontal agreement, that means it is for price fixation or not. So you are supposed to do your self-assessment test with this particular session. So for this, we will meet in next session with the price bid rigging agreement. So for today, thank you very much.